rather than general conservatorships. I mentioned my son has a general conservatorship. Generally, those aren't granted anymore for developmentally disabled persons. And that's why we're focusing on limited. The limited conservatorship is the conservatorship in California that was specifically designed to address the needs of our developmentally disabled community. Recognizing the fact that our kids with developmental disabilities have a really broad range of capacities and abilities and difficulties. So it's designed to be tailored to each individual.
So if I can jump in really quickly. Yep. Hi, I'm Gloria. Sorry, I've been trying to do the technical side of it. I'm still learning, everyone.
Luckily, you're doing
Gloria,
that.
Perez-Stewart. And I'm a lawyer here in LA. And yes, and like Jenna, I am a mom of a 21-year-old with autism and who does have a limited conservatorship as well. Now, our previous discussion, you can go to Facebook page or even I think the recordings. If you've registered for these webinars, you should have received the last recording. If you haven't, please shoot me an email and let me know so we can send you that link. But the previous recording discussed other options to limited conservatorships that we advise parents to check out before you go the route of a limited conservatorship for your child with developmental disabilities. And some of those things that we discussed were supported decision-making, and we gave some really good info on that for parents. One of the questions that I get asked, Jenna, and maybe I'm sure you know this because you've been in practice a lot longer than I have, but you know, someone asked me once, well, is a limited conservatorship just a lesser form of a general conservatorship? Have you ever had that question?
Well, I get it as what is the difference? Especially because people think a limited conservatorship is not, probably not maybe strong enough. They feel like it's like you said, maybe it's a lesser form. A limited conservatorship, it's called limited because we are limited to asking for 7 powers. In a general conservatorship, there's just some standard powers that are granted with every conservatorship. So it's a one-size-fits-all. With a limited conservatorship, there's only 7 powers that we can ask for, and you ask for whichever ones seem most appropriate for the needs of this particular disabled person. So you'll hear me say it's the proposed conservatee. That's the person that the proceeding is about. So as I said, there's 7 powers you can ask for. Now, the thing that's interesting is that if you have all 7 powers of a limited conservatorship, it's actually a more powerful conservatorship than a general. Because there are certain powers that you can ask for and have granted in a limited conservatorship that you would have to petition for separately in a general conservatorship. So why don't I just go over those powers, the 7 powers that you can ask for in a limited conservatorship. Okay, and so those powers is the right to fix the residence of the proposed conservatee. So that's just deciding where the proposed conservatee will live. Access to confidential records and papers, which is handling mail and having rights to reports from any source. Then the right to marry or enter into a registered domestic partnership. With that power, you have the right to consent or withhold consent to that. Also, the power over the conservatee's right to contract. That means the conservator decides whether the conservatee can or cannot enter into a contract. And then medical treatment, the right to give or withhold consent to any medical treatment. Then the other one is the right to control the conservatee's social sexual contacts. And then the right to make decisions regarding the conservatee's education. Now, a number of these types of powers are not granted in a general conservatorship. In a general conservatorship, there's no right to control confidential papers or records. A conservator doesn't handle the mail of the conservatee, doesn't have any right to do that. doesn't have any right to withhold consent or give consent to marriage or domestic partnership, can't control social sexual contacts. And a conservatorship of the person, in a general conservatorship, there's no power to void a contract, which is essentially the right to contract. Practically speaking, means that if someone influences a conservatee to sign a contract, as the conservator, you can cancel it without any kind of penalty.
I want to just really quickly jump in. So we did have a question in the chat, and I'm sorry, in the Q&A. I'm just making up my own stuff here. And it was from Joey, and it's, hi, is conservatorship in California synonymous to guardianship in Texas? Yes. So so briefly, the part one of this webinar was certainly more broad in that it wasn't California specific. Supported decision-making, adult guardianship in general is nationwide. So in California, this particular webinar, though, we're speaking solely to limited conservatorships in California. But yes, it is synonymous with adult guardianships in Texas, yes.
Yes, so in California, we have an age limit that determines what we call it. Anytime that there's a proceeding that is dealing with making decisions over the care and custody of another person, in California, if that person is under 18, it's a guardianship. If that person is 18 or over, it's a conservatorship. But it's that same concept. It's a proceeding that deals with the care and custody of another person.
I kind of want to give a little bit, I know we've already started talking about the 7 powers that are discussed with the limited conservatorships in California, but I kind of do want to say, simply because I'm from Texas, and it was different for me to understand the process here. So it was good for me to understand the history. And I know that the history for limited conservatorships, at least in California, started in 1980. And that was when the legislature here approved Assembly Bill. It was 2898. But it grew out of the disability rights movement here. The disability rights movement, it was huge in California, and it grew out of that and the deinstitutionalization movement of the 1970s. So that's kind of, and it was so that you had limited powers. You're limiting the power of someone to, and that's why Jenna's speaking to the seven that are addressed here. And every one is addressed individually by the court when we go in front of a judge and we ask for these 7 powers for a person with developmental disabilities. Jenna, do you want to?
Yes. So the courts in California, the legislature, through these movements, finally recognized that the developmentally disabled are in a historically oppressed group that are frequently taken advantage of and have their rights trampled on. And unfortunately, that is sometimes family who is doing that. So it was really, our limited conservatorship has some very specific duties and responsibilities and requirements that come out of that history that Gloria mentioned. So for example, we're limiting our powers to these 7 powers that you can ask for. Although, as I mentioned, a limited conservatorship can actually be much more powerful, much more restrictive than a general conservatorship. Again, but it's tailored to the unique needs of the individual. The second thing is, when a conservator is appointed, they have an affirmative duty to exercise their power in a way that, one, respects the desires of the conservatee and encourages as much independent, decision-making capacity, participation, as that person can manage. We want them to be as independent as possible. We want to be assisting them where they need the help. Then the other thing is, a conservatorship in general is what we call a protective proceeding. The whole point of it is to protect the person that the conservatorship is about. The basic requirements are that they're unable to provide for their own needs for shelter, food, and medical care. We want to make sure that someone can make sure those things are obtained for them. But by doing that, they do lose civil rights. Anytime someone doesn't have decision-making power over their own life, they've lost their civil rights. So because that is a proceeding where the civil rights are being affected, it's mandatory in California that an attorney be appointed for the proposed conservatee to protect and advocate for that person's rights. So that's another layer that's part of the limited conservatorship, that is the law in California recognizing that this is very serious. It's very serious. Civil rights are being taken away. And more recent developments, we also have a review process that goes on after the conservatorship is established, where a probate court investigator checks in on everything to make sure that the conservatee is still being taken care of, that they're not being taken advantage of by the people that were now placed in power. So we have these review investigations that occur at 1 year after appointment and every 2 years after that for the life of the conservatee.
Do you want to talk about the role of there's also the court investigator that's appointed. Do you want to talk about their role?
Yes, that's right. I did mention the probate court investigator, but didn't say anything else. So yeah, so part of the overarching procedure is a petition is filed. It's asking the court to appoint someone as conservator, and it's asking for specific powers. The probate court appoints a probate court investigator, and that person's job is to interview the proposed conservatee, advise them of their rights under the law, and then make a report to the court, which states whether the person seemed to understand to any extent the rights that were explained, any response that they gave to the advisement of their rights, one of which is, do they want an attorney? They'll get appointed one whether they want one or not. Do they want to appear at the hearing? So just that their rights were explained to them, what level of understanding they exhibited. And then the investigator also interviews everybody else involved, the family, the proposed conservators. They'll talk to the service coordinator with the regional center, teachers, program staff. They'll try to pull in as many contacts as they can to get a big picture. And then they make the recommendation to the court. Their job is to answer 2 questions. Is this conservatorship necessary? Are these the right people to do the job? So that's what the report is all about.
And I want to talk a little bit about that, because I get families coming in that are, well, I've been doing this obviously since my child was born. Why do they have to come in and talk to my son? He can't verbalize that. What do you mean? The bottom line is we're protecting someone's civil rights, and we're ensuring that this is a necessary thing. And so parents that choose to go this route, you're usually the petitioner, right? If you're a parent of a child with developmental disabilities, chances are you're going to be the one that's going to be the petitioner in this process. Understanding though that the court then is going to appoint counsel for your child. And the court is also going to appoint a court investigator that comes out and does all of these sort of checks. And yes, they will have to, typically it's sort of the family goes to the other room, or, maybe to the living room or the dining room. And, the person is asking questions of the person with disabilities, and whether their report states whether or not they felt that they understood or didn't understand. This is just simply keeping their civil rights intact.
Absolutely. And the process is the process. So the court doesn't care if it's a parent, a sibling, a stranger, a professional, a family friend. The system, the process that they go through, it has to be the same to just determine that this is necessary and that these are the appropriate people. And they do the review for the same reason. Yes, generally your family members are the most invested, and they're going to be the best conservators. But that's not always true. It's unfortunate that sometimes you have a family member who takes more advantage because they're in the best position to do it. So it's just important, and it's very important for the courts. If they take a person's civil rights away, they have to be sure they've done the right thing, and they have to keep checking in.
Jenna, one of the questions that we had, oh, you did answer it? Okay. It was, are parents present when they interview the conservatee?
Yes, you answered that, Gloria. Okay. Oftentimes they'll ask you, can you please go to the next room? But then, and this is a very similar process that occurs with the court-appointed counsel. Once an attorney is appointed, that person will come out and they'll meet with your child. If it's feasible to meet alone, then they'll do that. A lot of our kids are not comfortable with that. So I serve as court-appointed counsel in Sacramento County, so I've done conservatorships from both sides, as well as the parent side. And often I am interviewing that person with the family, the proposed conservators present, and I just make note of that. And oftentimes that's necessary because the person's not going to be comfortable if they're alone with a stranger. So it's just very dependent on that person.
Kristen, can you put in, so parents that are interested in that court investigation process and want to look at the law itself, that's probate code section 1826 here in California, California probate code section 1826. Kristen's going to put that in the chat. Just, I know some of you are nervous and want to read up a little bit about what they do, and you should definitely go straight to the law and look at and see who they're supposed to interview, how that looks. Go ahead. Sorry, Jenna.
No,
I'll just keep interrupting you when I have little things to insert, but go ahead.
Okay. So, okay, I think I'll kind of circle around and try to give a overview of the whole proceeding. So the first thing that starts is all the documents get prepared. There are a number of forms that have to get filed to start a conservatorship.
So many forms.
And I have a specific list. So I'm going to do the broad overview first, and then we can sort of circle back because a lot of parents ask, can I do this myself? So we'll get back to that question and kind of go over those forms and where you find them and things like that. But we'll kind of start with the overview first. So there's a bunch of forms that get completed and they get filed with the court. And those are the ones that give all the information about the proposed conservatee. And then also ones that give information about the proposed conservator, ask a lot of really personal questions, like arrests and bankruptcies and other things like that, because it's part of the background check that's being done on the conservators by the probate court investigator. And then things that acknowledge your responsibilities and duties of a conservator. So those all get filed, and then we get a hearing date. Now, typically, hearing dates are 2 to 3 months from the date of filing the petition.
Not now.
That, yes. There's a lot of things that I'll say that are typical, but nothing is typical right now. A lot of courts have a huge backlog from being shut down, and just different proceedings and different caseloads. So there's no typical right now, but we'll kind of go with the typical, and then things are also changing as far as how hearings are held. A lot of hearings are now on the Zoom platform or by telephone, things like that. So you have this hearing date. So in between the date the documents get filed and the hearing date, there's a lot of things going on. The probate court investigator is appointed and they start their process. We request appointment of counsel for the proposed conservatee. Once we have counsel appointed, then that person starts their job. Now, different counties do court appointments differently. A number of counties use private attorneys that are in practice, and they get appointed off a list. I think there are PVPs in LA County. They're just called court-appointed counsel in most counties. Some counties have a division in their public defender's office that actually is court-appointed counsel for conservatees. Mm-hmm. So you may have, in your county, it may be a private attorney or it may be from the public defender's office. So that person starts doing their job. Then there are certain family members that are entitled to notice of the petition. So once we have that petition filed and we have a hearing date, then a copy of the petition and a notice of hearing that gives the date and the address of the court gets mailed out. That goes to parents, to grandparents, and to siblings.
Yeah. I've had families, now Jenna, have you had this issue? Because I've had families where it's been a mother, say a mother or a father, but typically the mother who has really had no contact with the other parent for a number of years.
Yes.
Yet the other parent retains rights. There's
Yes.
never any sort of proceeding in their divorce, or if they were married, or any kind of custody thing that stated that that person, that they didn't lose their parental rights. So whether or not they were involved. So I've had moms, especially moms, say, well, he hasn't been involved. Why does he get to say anything? That's his right. And, we have to let them know that, hey, this is your child, and this person is now petitioning the court and will be in front of the court asking to take these powers away from your child. You now have the right to come in and contest it or otherwise. But
yes.
Jenna?
Yes, people are very concerned about that. One, because they may have no idea where that person is.
Yep.
Two, that person, they may feel that person is a danger to their child. That person hasn't been involved. Another is that, well, we got divorced long ago. I got sole custody. This is just going to be another opportunity for things to get, brought up. And those things are all unfortunately true. But the law requires notice go to biological or adopted parents, grandparents, siblings. That just, they are entitled to notice. One thing to remember is when your child's 18, your parental rights are gone. That's why we're doing a conservatorship. There are no parental rights. So other than notice, there's no rights that are invested in.
For the future, for after 18, yeah.
Yeah, for that person being a parent. The court doesn't care if they're a parent. They're going to care, is the person petitioning good for the job? And I have that asked when it's that person who says, the father hasn't been involved, since 15 years or something. The court's going to see that. If the father shows up and files an objection or files a counter petition, they're going to say, okay, what makes you better? And if there is nothing that makes them better, they don't have a chance. So it is frustrating that, someone who hasn't been there, hasn't been involved, gets an opportunity to show up and say something. But that's the right, that's the law, has to be done. However, if you can't locate that person,
yes,
that is a reason to ask the court to dispense with notice. So you just have to file something that gives the court enough information to know that you tried to find them and you couldn't. And then you file that, and the court's not going to require notice to that person. Now, again, if you know where a person is, but they're a danger to your child, then you also tell the court, I don't want to give notice to this person for these reasons, and the court can dispense with notice for that reason as well. So there are ways to deal with not knowing where a person is, or them being a danger and just needing to not give them notice for that reason. Okay. So then, so that happens, and then it's a waiting period. The other thing is, there's one other piece that's very important, and that's a capacity declaration. And this is a form that is signed by a doctor under penalty of perjury that really evaluates the cognitive functioning of the person who needs the conservatorship. So in California, there's no lack of capacity that's based on a diagnosis, not autism, not dementia, nothing. The diagnosis is just helpful information. What we really need to know is, what is the cognitive functioning of this person? And that's the capacity declaration tells us. Mental functioning is evaluated in a number of different areas, and that capacity declaration gets filed, and it's basically the main piece of evidence for the necessity of a conservatorship. So, and my recommendation,
so you can go through it really quickly. Can you see that?
What?
Can you see my screen?
Oh, yes. Yeah.
There's the capacity form.
There's the capacity declaration.
We see these filled out. Oh my God. I can't describe the amount of effort that it takes to fill one of these out correctly.
So I tell my clients, what I do is I hand this capacity declaration to my clients, and I highlight the heck out of it.
Yes.
I highlight it like crazy. I highlight it in a way that I am pointing out where information needs to be, and I'm careful not to highlight it in any way that makes it look like I'm telling somebody what to say.
Very tricky.
But if it's not done correctly, it's rejected by the court. It has to be signed and dated in 2 separate places. It has initials. There's initials required on the last page. 7B. If the person lacks the ability to give informed consent.
This right here.
If the doctor doesn't date it, then the court's like, oh, it's not verified. There's a spot for writing in the last date you saw the person. And if that's not. That's
right
here. It's on the first page. Yeah. If it's not filled in, then again, they reject it.
They'll reject, yeah.
Yep. So,
there's a lot of little nuances to these forms, and they're the worst. So this is GC 335. Yeah, just
so the first page is the doctor's name and address, their licensure, the name of the conservatee, when they last saw them, and whether the conservatee is or is not a continuing patient. Was this a one-time capacity evaluation, or is this a regular patient?
Yeah.
Yep.
Is or is not. You see that?
Yep. And then the next section is that ability to attend the court hearing. So it's
and sometimes we won't have the date though, Jenna. Speak to that, because let's say a parent is doing this themselves.
Yeah.
And they don't have a court date yet, but they want to get the capacity form filled out.
Yep. And in fact, every capacity declaration I send out does not have a hearing date on it.
Yeah.
So if you go up to the top, bring it down, perfect. So to the physician, so right after the title of the document, there's to the physician, there's A, B, C. A is able to attend a court hearing. You check that box. And I always leave the date blank because I never know it at that point. And then B is has the capacity to give informed consent. Check that box. Box C is for patients with dementia or major neurocognitive deficits. So in our limited conservatorships, we're generally not checking that box unless this is a conservatorship that's being done for a much older developmentally disabled client, which can happen. Then pages 3.
Oh, go ahead. Go ahead.
Yeah, so pages 2 and 3 and 4 is really going over the cognitive function in a bunch of different areas, just orientation, information processing, memory.
If you look at the top of 6, it says check this is for the physician, but they're checking the appropriate designation. If A is no apparent impairment, B is moderate, C is major impairment, D is so impaired as to be incapable of being assessed. E, which has been happening lately in some of my doctor forms, is I have no opinion, which that's another issue. But yes.
Yeah, and you know what? And if they check the box, it's fine. It's when they don't check a box. They're like, oh, it doesn't apply, so they just don't check anything. It's like, no, you have to say, is there no impairment? You don't have an opinion, you have to check a box. So,
but let's talk about the issue though too. This is another issue though, Jenna. If parents come to me at age 17 or they come to me right at age 17, 18, the other issue is that typically they've got a pediatrician and then they're moving to an adult doctor. So then I have had so many parents, so I'm grateful. I'm so happy when they come to me early because then we can kind of smooth out some of these issues ahead of time. But what happens is we'll get a doctor who's the adult doctor, who's just the new doctor, doesn't really know much about it. And it's like, I'm not going to fill this out. I have no, so there's that challenge, right? Jenna, how have you gotten around that?
So one of the things is I always ask the parents, what's the doctor that's best equipped to fill out this form? Because a lot of our kids have multiple doctors. They have psychiatrists, they have neurologists. And in general, if a client's child has a neurologist or a psychiatrist, I prefer that doctor. That's the one we want it to go to because they are best equipped to do cognitive evaluations and do them fairly quickly. So,
can you see then, can you talk a little bit about that number 7, the ability, then how the doctor needs to initial right here?
Yes. So this is very important. And it's one of the most important things because for most of us, For most of us, the most important thing is the medical. Our kids can, maybe have a lot of capability in a lot of areas, but if they have to make a decision on whether elective surgery is in their best interest, as soon as someone says, oh, well, then we stick a needle, and they're like, done, no, this is the main thing. So this is the question of, does this person have capacity to give informed consent? Can they understand the costs and benefits? And if they can't, then, so A is, yes, they have the ability to give informed consent. If the doctor checks that, the conservator does not have exclusive authority to give or withhold consent. That remains with the conservatee. They can say no. The second box is the doctor says this person lacks capacity to give informed consent, so they wouldn't be able to fully participate in the treatment decision or understand the risks or benefits. If that box of B is checked, then the doctor must initial to basically confirm that. Here. So what Gloria had highlighted in blue, I highlight that on every capacity definition. It's like, if it applies, initial here. Because those initials, again, if they don't initial, then it's deficient and you have to get it done again, or you don't get exclusive authority.
Okay, I'm gonna go ahead and stop the share. Okay.
Yeah. So like I said, I highlight that form. It's like, here, look, 6A, B, C, D, just look here. I highlight that instructions on check a box. These are what the boxes mean, and dates and signature and initial. I highlight those, and I tell my parents, make an appointment, take the form in with you, get the doctor to do it right then. A lot of doctors, especially if you have a long relationship with them, are going to do that. If you're dealing with the big HMO like Kaiser, if you have to send it through the medical secretaries, you may never see that form because of the bureaucracy.
Can you go into, there's another question, if you don't mind me interrupting you. It's another Linda Litzinger. Hi. Okay, so this may be in the weeds, but no, trust me, it's probably not. When there's a joint conservatorship, and for example, the mom writes down her wishes that if she dies, she wants a friend, not the dad, to be the conservator, what does the probate court do with this? Okay. This is actually, this gets asked a lot, and there are ways around it. But go ahead, Jenna. Yeah. I know how I do it.
Yeah. So essentially, I always tell those people, put down in writing your nomination of who you want to be the next conservator. The court gives it weight. And again, when I mentioned parental rights are gone, we're talking about what's the qualifications of the person in front of us asking to be appointed. Because what happens, mom dies or mom lacks capacity now and she can't do the job anymore. Friend knows that she's supposed to take over. So friend files a petition for appointment of successor conservator. And then the court is looking now, is this person appropriate? And yes, that father, he's going to get his notice of this petition and he can come say whatever he wants. That I'm the dad doesn't matter that much. It's I'm the dad and I've done all these things and I'm in a better position. That's what they want to hear. If they don't hear that, friend is the one who's going to get the job. But it's important that those wishes for everything, please. Wishes need to be in writing.
Yes. No, I mean, again, these aren't legally binding, but the court gives it weight. None of this is legally binding. Yeah, the nomination of guardian, nomination of, some people even do, and I've drafted these for people, it's sort of a confidential exclusion document. It's like who I would never, I don't want this open unless I die, but hey, court,
not this person,
I never. And there are reasons for that. So yes, that you can make sort of confidential, again, not legally binding, but this is something that you want with your estate plan. This is more of estate planning stuff. It's more things that you want with your estate planning documents and that you want it sort of in there so that people know this is how things should be laid out for the court.
Yeah, and it's gotta be in writing because that friend can't present anything to the court that's not in writing. I mean, she can sign a declaration that says, this is what my friend said, and this is why she doesn't want the dad. But if the court has something in the prior conservator's writing that says, I want this person, this is why, she knows him, she knows the job, she knows what I want for him, she's, all those things, that matters to the court. So
now, one of the things that we do also, though, is several conservators at the same time.
Yes.
And yeah, it doesn't have to, it's not limited to one. I don't think is there a limit? I've never tried to do a million people, but the most I've ever asked for is 3 and the court's granted. So it's typically, in those cases, it's been mom and maybe 2 adult children, that are capable, or maybe mom, dad, and another adult child. Yeah.
Yeah. So I have requested and been granted 4. I am in the process of requesting another one that is 4. And in this case, the court is asking me for a declaration on why 4 is appropriate. So again, they just want to know why. The reason it matters is the more people you have serving, the more opportunity you have for disagreement. Disagreement among conservators is never good for the conservatee. Never good. So
it's sort of like that many parents with rights.
So in this case, where I'm asking for 4, it's a sister and 2 nephews. No, it's a sister, 2 nieces, and a nephew. This is an interesting case. I am getting a conservatorship started for the first time for a 92-year-old developmentally disabled woman. She has literally outlived everyone in her family.
Wow.
Her parents, 8 of her 9 siblings. And honestly, they're worried that she's going to outlive all of them. And so that's why there's 4 of them. There's the sister who's 87, who's not ready to give up responsibility, but she knows she needs a little help. And she knows she's going to die. She knows her sister's outliving her. So, yeah, it's all the family is acting together. They want to make sure she's taken care of. I think the court will end up appointing all 4 of them.
That's a great case.
Yeah.
I do want to throw in, though, because this is a recent call that I had, and it was, the idea of not doing it, and the previous webinar that we had talked about supported decision making. I'm a full proponent of supported decision making. People should know that right away. And that's one thing I ask every client who comes in. It's, what have you done elsewhere, outside of this, in terms of your informal, your support network, right? Do you have a support network? That's another thing. Now, one of the things that's interesting, though, is when I come up against a family who's never done anything, because they've had a good support network, is what you're saying, right? That's similar to your case. This particular case that just came recently to me it's a 45-year-old whose parents have always taken care of her. So and there's a big extended family, so it was never really a worry. We don't really have to do all this. She's living at home. Except parents at the time she's 45, so they're in their maybe late 60s, early 70s, split up. And mom is, really never worked and trying to make her way. Dad gets remarried, and the new wife doesn't want the 45-year-old there. So so then who comes in? There's no conservator. Nobody. There's never been a conservator. It's always so. Guess who comes in at that point? In California, the agency that came in, it was the regional center, took her out of the home because dad was like, well, we don't really want her here, whatever, and there was no conservator. Put her in a home. So now the whole case is sort of how to apply for limited conservatorship for her and get her out of that home. But these are things that sort of come up as people get older that we don't think about when our children are just turning 18 or 19 or 20. Yeah.
So the other thing is, for a very long time, families with the support network and long-term relationship with doctors didn't need to do a conservatorship. The need just never came up. Oftentimes you had the family doctor, and it was the family doctor that was there when the kids were growing up, took care of the parents, took care of the kids as they became adults, and just, we understand, it's all good. We'll do the surgery. You sign the forms. It's fine. We don't live in that world anymore. We don't live in the world where a person over 18 can just have someone else sign. The HIPAA rules, the fear of lawsuits and other things by doctors' offices and medical groups. It's a lot harder to just get by informally, especially with medical care. I'd say for the vast majority of older conservatees, parents of older conservatees that come in, that's what happened. They hit a roadblock on medical treatment. Now, if it's emergency care, if it's life or death, treatment gets provided. No doctor is going to let someone die because they couldn't sign a form. But if it's less than an emergency and they refuse treatment, they can't do anything. So if it's, for example, family came in, the son was in his 30s. They'd been doing fine, hadn't run into any problems because he had just needed routine medical care. And basically the doctor's office just had him, sign the HIPAA waiver form. And so all the appointments were made by mom. Everything was fine. And he got a tumor on his forehead. And it was a benign tumor. So it wasn't life-threatening in any way, but he was afraid of that. They gave him the explanation of removing the tumor, and he was scared, and he said no. So they couldn't do anything. The tumor is, eventually the size of a golf ball. It's causing pain, but he doesn't want it removed. Well, that's what eventually prompted them to come in, because they finally needed to do something, and they could not do it without a conservatorship. So that's what we're finding. There's fewer and fewer and fewer of these cases where a family is able to just do it informally. It gets hard, especially the more truly limited your conservatee is. The more impaired they are, the harder it is to get by with informal assistance.
Do you want to talk about, so you've spoken about the notice of the hearing to immediate family members,
yes.
But can you speak to the citation, the service for
yes.
the person? Yeah, okay.
Yep, so actually there's one other entity besides family that gets notice, and that is your regional center. Up here, my regional
outside, I have to jump in, sorry for that, because I'm speaking as sort of too, because I know we've got people from different states here. So our regional center in Texas would be, it's the old name. I only know the old name because I don't remember what they've changed their name to, but maybe it's Integral Care now, but it's MHMR basically. It was the old MHMRs in Texas.
So basically the regional center is whatever entity gets the federal money and the state money and is responsible for advocating and connecting consumers with developmental disabilities with services. So yeah, like my regional center is Alta. They cover like 10 counties in California. So it just depends where you are. You'd be Googling your local regional center. If you have a kid ready for conservatorship, you have dealt with that regional center a number of times.
They provide respite and other sorts of services.
Yeah.
So what is their role, Jenna?
What?
So what is their role? They get noticed. They
get noticed, and they also file a report. They are giving their recommendation on whether conservatorship is appropriate. They give their opinion on the powers that have been asked for, and then they recommend whether or not these petitioners are appropriate or not. So that's what they get to recommend. And again, it's a recommendation. The regional center makes a recommendation. The court-appointed counsel makes a recommendation. The probate court investigator is making a recommendation. The judge's job is to decide how much weight to give everything. Out of those, your court-appointed counsel and your probate investigator get the greatest deference. Alta, sorry, so used to my regional center. So the regional center is generally given a lot of difference, but they can be argued over and overruled.
And just to be clear, there are differences in regional centers. I've seen that in the regional center reports for some of my clients, where some will, some will say, sure, that, you know, we think this is fine, all the powers, and then some, as a matter of just practice, this is what they do. They recommend parents not have a certain rights.
Yeah,
I say parents, petitioner, the proposed conservative.
So, yeah, regional centers differ from center to center.
Yeah.
I'm not sure how all of them do their process. I know that my local regional center, they basically have a committee. So the notice comes in that this person has a conservatorship proceeding pending. They need to file a report. Generally, they kick it out to the service coordinator. Unfortunately, for all of our kids, generally they have just transitioned to a new service coordinator who doesn't know anything, which I think is a huge failing in the system. But they kick it out to the service coordinator to do some kind of, meeting, maybe telephone call, report, and then basically it goes to this committee, and the service coordinator may pitch their opinion to this committee, but the committee's really just looking at the huge voluminous record of all the ISPs, IPPs, all those things that they have in that record, their psych reports and everything, and then they just make a recommendation, and that goes in the report. Some of it is very policy based, and it's cycles. Our regional center is consistently against social sexual contacts and marriage as powers that should be granted. They are fundamental rights. They are some of the most fundamental rights that we have. However, it is also a huge area of need for our kids. This is where the developmentally disabled, the cognitively disabled, those with dementia, all of these groups of people, this is where they get abused the most. We have a lot of laws about financial abuse and other things like that. Pretty much spouses are exempt, which means the new frontier of elder abuse and dependent adult abuse is marrying someone to benefits, other things. And that's why the right to withhold consent to marriage is so important. This is the next frontier. This is where we are seeing the financial abuse cases. They're marrying to have access. The other thing is social and sexual contacts. Who your friends are, whether you get to see them or not, it's just so fundamental for all of us. And we are realizing that more and more as a lot of us are locked down, how important our social relationships are. And generally, most parents aren't really trying to control that, but the regional centers see that as a control issue. Now, the other problem is if someone convinces your 19-year-old daughter to get in a car and leave, if you don't have social sexual contacts control, you can't get her back. So she can be taken advantage of, God knows what, and the cops can't go stop that car and bring her home because you don't have any right. Because all that the person with her says, oh, she wanted to come with me, we're done. If she's not as limited verbal, we get these calls. Go ahead. The regional centers, they have their reports. They're not parents. They're not seeing this. They're not staying up at night worrying. So they have their policy, viewpoint, and they will stick with that. Now,
but ultimately, the court is going to look at what you are asking for as the petitioner. And if you're listing these, you list the reasons, 'cause Jenna, we go into, for each of our clients, we go into, and you do the same, but we go into why this particular power is being requested. So the court will give weight to that as well. So this.
And for any of you who are doing it on your own, if you're in the courtroom and the judge is asking, well, the regional center says no, why do you want this power? Always go back to the safety, because that's what the courts, that's their job. They're making sure this person is safe. We're taking civil rights away, yes, but we're doing it to make them safe. So if you are focused on the safety, that is the winning argument.
For parents that are doing themselves also, just really quickly, it's California Probate Code section 1827 that discusses the assessment by the regional center and the protocol and what they have to go through. Another question.
Yep, I see the question.
Okay.
18 next year, August 2021. Okay, so for example, my county.
Let me read it out loud real quick. Due to the current backup, if my son is turning 18 next year, August 2021, when would you recommend we start filling out forms and filing? I know what we're doing here in LA County. LA County, we're pushing these out till 6 months. Roughly.
Okay.
We're at 6 months right now. So if I file something today, I'm not getting a court date. Where are we? August? Now we're looking at January.
Okay.
We were December a couple weeks ago. Yeah.
Yeah. So currently we're about 4.5, 5 months to a hearing date. So generally I would say about 4 months ahead is when you want to, if you're going to meet with an attorney, about 4 months ahead is when you want to meet with attorney, so that everything gets prepared and filed at least 3 months before. I would say now you're probably looking at 6 months. If you're in a large county like LA, then 7 months may be more appropriate. If you're in I'm in Sacramento County. Sacramento County right now is about 4 months. So we're only about a month behind. So I'd say 6 months is generally good. If you're in a really large county, a little earlier than that.
Okay. Do you want to answer the next question? Hey, Robert's on. Can you ask for a temporary conservatorship while you wait for a permanent one?
Yes. So, especially at the beginning of this, I was, filing my petitions. And in fact, we had a shutdown, so you couldn't even file a petition for like 3 months. So when you had the backlog, and then 2, you have everyone who's been waiting to file. So I started filing, not knowing when these dates were going to be coming up. And so yes, if the hearing date you get is after your child's 18th birthday, you can do a petition for temporary conservatorship. So a conservatorship cannot be granted until the 18th birthday.
Yes, that's a very big question.
So I say, yes, you get it in, you get it filed, you hope it's after their birthday, especially a lot of the ones I'm doing right now. They end up being like a week later or 2 weeks later because, we just couldn't get in earlier, and then we didn't even know what the dates were going to be coming out. So the need for the temporary doesn't show up until their 18th birthday. So what you really look at there is how long is the gap between the 18th birthday and the hearing, and what is likely to happen in there. Now, we have some kids where it's really no big deal. There's no pressing medical issues. There's no appointments coming up. There's nothing that's going to create a problem. Then you can usually just wait it out. You have some that have a lot of medical issues. They're fragile medically. They're in the middle of some kind of very important transition or dealing with a regional center over a difficult issue. And there's a concern that the regional center will then just not talk to the parent and do whatever they want. Those are when you go, okay, now we need to do the temporary. And most counties have a procedure for an ex parte, which is an emergency. So basically, on the 18th birthday, if you have one of those situations, medically fragile, for example, is a great one, unfortunately. you have an emergency on the 18th birthday. It's,
Mhm.
you don't know when the crisis is going to happen, but it will happen, and you need to have the power ahead of time. So ex partes often get granted the same day they're filed. Some counties are different, so it may be like a 5-day, a 1 to 5 day, but basically it's a very short timeline. So if you have an issue like that, then you can do an emergency temporary, but you can't do it till the 18th birthday because there's no grounds for a conservatorship before.
It's a tricky time frame. It really
It is.
And now here in LA, we have been, you know, we were lucky, at least through the shutdowns, they were doing emergency orders and that sort of thing. And if there was a good reason, it was tricky for some of my clients. Their children were turning 18, but not going anywhere. So it was kind of, you know, we kind of waited out on an individual basis. So then because we're at the end of our time, let's just quickly go through the rest of the process. And then I wanted to talk really quickly about voting rights.
Okay, so yes, so as I said, that capacity declaration gets completed, it gets filed, then those reports go in, and then we have a hearing date. And the judge is now looking at the reports, the capacity declaration, make sure everybody got notice that they were entitled to, and if everything's in order, granted, and then the judge signs the order, and then the document that's called letters of conservatorship gets issued by the court clerk. That's the document that you actually need to show your authority. The letters is what goes to the doctors, the schools, the regional center, all of those people. Then there's a couple things that have to happen after that. One is a notice of conservatees' rights, goes out to everybody that received notice of that petition. And then you complete a form and file it that talks about the appropriate level of care for the conservatee. So it's just basically an assessment of what are the services and the assistance that need to be provided so the conservatee can stay living in the home that they're living in at that time.
Mm-hmm.
Once those are in, then that's the end of the really active court-related duties of the conservator. At that point, it's established and it's just ongoing. So the investigator does that 1 year and then the 2-year investigations thereafter.
I've had this question. I want to throw this one out though. People have asked me, well, does my child, if they go with me to the court proceeding, which now everything's remote. But if they
I'm
go
sorry, you mentioned citation. Yes, that was the other important thing. So the conservative,
you have to serve the person.
You have to serve them. Someone has to serve them personally.
Not you.
With a copy of the petition and this citation that's issued by the court. That can be anybody in the world over the age of 18, not the petitioner. Friend, relative, anybody, just hands it to them and signs a proof of service. That gets filed. The conservatee may or may not go to that hearing. Okay. So if the doctor excuses them, they don't have to come. Another possibility is if the doctor said, yes, they're medically able to come, but they really don't want to, and they express that to the probate court investigator and their attorney, then the probate court investigator may essentially waive their appearance, or their court-appointed counsel may waive their appearance. One of the things I tell people is, especially when you're talking to the doctor, what the form says is medically. If they are medically able, they should go to the hearing. Now, medically able, most people are going to think, can they physically get there? This is where it's an advantage when you have a psychiatrist filling out your capacity declaration, because they'll get this. What if it's so stressful for your child that they're going to feel anxious and sick and scared, and they might scream the whole time? We don't care if they're fine and happy and they scream the whole time. That's everybody else's problem. But if they're so stressed that it's bad for them, as far as I'm concerned, that's a medical excuse. So those are the things you talk to your doctor about at the time that they're filling out the capacity declaration. But if they're physically able and they're not going to mind being there, they're not going to be a danger to themselves, then they should go.
And the court will generally ask them, do you understand this? And, you know, that sort of thing. My son, as a little story, my son, when he was asked that, said yes, yes to everything. And then promptly, then puts his arms around both me and his dad, who were both, you know, petitioning the court, and burps. Right for the judge. So that was awesome. So yeah, there are differences there. I want to go really quickly into the voting rights, though. It does come up as an issue in every limited conservatorship, and that in California is governed by Election Code 2208. But basically, we feel in California that a conservatee is not automatically deprived of the right to vote. So
as long as they can communicate in any way a desire to vote, then that voting right is not restricted. And like in my county and my surrounding counties, because I practice in a number of counties, essentially if they can communicate, then no one's going to recommend they lose their voting rights. Even if they don't say, I want to vote, if they have the ability to express themselves verbally, their right won't be taken away.
Jenna, before we go, can you answer those two questions, or do you have to go?
I really have to go. Let's see.
We can put it out on Facebook for these last two.
If a person wants, and so let's see. Typically, that you've got that hearing date months and months in advance. So they're probably going to expect that person to be there at that time, regardless of barriers, because there's usually enough time to do that. And already in 18, yes, if your child is already 18, there isn't a conservatorship in place and something comes up, yes, that's a reason. You have to file the petition for the limited conservatorship and then file the temporary that covers the time until that hearing. But yes, and so Gloria, feel free to give everybody my contact information. So email me questions. I apologize.
I appreciate it. And I will get Kristen and I. Bye, Jenna. So Kristen, can you read out, because we are having an issue with the chat box. Kristen, can you read out Jenna's info? So Jenna serves, for everybody on this call, Jenna serves Northern Cal. She serves Sacramento County and all the counties around there. I serve Southern California. Jenna, information, do you have that, Kristen? Is Kristen on? I'll go ahead and give mine while we wait for Kristen to come on. So mine is Gloria at gpslaw.net, or just gpslaw.net to schedule an appointment with us if you just need general information. I'm going to pull up Jenna's really quickly for those of you who are interested. Jenna, so every lawyer works differently. You should know this. Parents can do this on their own. You really can. I've seen some of us that consult with clients. I do different packages in that I consult with them. Some people I just do the documentation as if they are doing it themselves. It really depends. Jenna's phone number for her office is area code 916-382-9270, and it's jtcampbelllaw.com. So yeah, and we will put this in because for whatever reason the chat was disabled today, and I apologize for that. But we will put this in on my Facebook page at GPS Law Office PC. So if you want to sign up there or like it, I think you'll get the notice, and we'll put in the all of the information here. Thank you so much. I appreciate everybody for tuning in, and we'll let you know when we do a new one. If you haven't signed up for my newsletter, do that at gpslaw.net. Thanks. Bye.